Good morning, everybody. Welcome to the holiday version of the EDiscovery channel. As you can see, we're all festooned in our holiday regalias. And I, of course, am Tom O'Connor from very festive New Orleans, Louisiana. Rocky Messing, as always, from probably not so festive for Christmas time, Tel Aviv, Israel.
We still celebrate around here. There's some celebrations going on.
Yeah, I understand. Do they up the security down the street for the prime minister?
No, we're still.
For those of you who don't know, Rocky lives down the street from the current prime minister. So security is, of course, always a concern in the neighborhood.
Yeah.
So we're really, as always, at the end of the year, we try to get a distinguished jurist to join us. And we are really happy to have with us the Honorable Paul Grimm, who I'm sure many, if not most of you know. Judge Grimm, thanks so much for taking the time out of your schedule to join us.
Happy to do so. Who could turn Santa Claus down, Tom?
You'd be surprised, actually.
Yeah.
As I said, most of you probably know, but for those few who don't, Judge Grimm sits in the district court, US District Court for the District of Maryland, and is down in the Greenbelt Courthouse. Is that correct, Your Honor?
Yeah, that is right.
And yeah, that's southeast of the city, down towards College Park, down that general direction.
Yep, it's the courthouse that's closest to the DC metropolitan area.
There you go. Again, I'm sure most of you are aware of Judge Grimm's background. Distinguished jurist, was a magistrate judge in Baltimore before he was appointed to the court back in 2012?
It was coming up on 10 years.
Yeah,
Wow.
10 years. Great.
I believe actually isn't today the anniversary?
Wow.
Yeah, it's actually kind of an unusual set of circumstances. The commission was signed on December the 6th, which was yesterday. But the effective date, I think, is somehow December the 11th, and that probably has something to do with when the oath was taken. But it's within a week. It's cool. This week or Monday. So,
well, congratulations on the anniversary. That's great. That's
Thank
great.
you.
So we usually try to, as most of our listeners know, this is an informal thing. We try to recreate the chatting at the conference in the hallway sort of encounters that we have. And in looking at your bio, Judge, I was struck by. I wasn't stricken.
Oh.
I was struck by something that I didn't know about you. That it said you were born in Japan.
Was
my late wife Gail actually, the first language she spoke was Japanese. Her dad was in the CIA, and they were over there for various reasons, which we won't go into. So I'm interested. What's the Japanese connection?
my father was not in the CIA, but he was an Army lawyer, and he was assigned to Yokohama at a time as part of what was referred to as the Army of Occupation, and which is true. It was 1951, yeah. So it was very close, within 6 years of the end of World War II, and he was assigned in the legal office there, and I was born there. We left when I was 9 months old, so unlike Gail, I never learned to speak Japanese except a few words that I heard my parents use. And probably those are best not repeated. But I do remember Ichiban, which means number one. So
there you go.
That's worthy of being repeated.
That's right.
And then we came back to the United States, and we came back to the United States to the Presidio of San Francisco. We spent some time in Charlottesville, where the Judge Advocate General School is, for the School for Army Lawyers, time in Germany, and time back in California. And then I sort of returned to what would become part of Japan, although in that time it was still sort of somewhat of an American protectorate, which is Okinawa, and was in high school for 2 years in Okinawa before he was sent to Vietnam, and I came back to the United States and graduated from high school in California.
So your dad was in Vietnam about the same time Gail's dad was in Laos when we didn't really have anybody in Laos. But
right.
Interesting.
He was the command judge advocate for the first field force in Vietnam, and that was his. I guess it was his last overseas assignment. He came back after that and spent the remainder of his years in the United States.
Wow. Now, you were also a JAG officer, correct? So that's a great follow-up, huh? Both you and your dad were JAG officers. Wow.
Yeah, I had an ROTC scholarship paid for my college, and then I owed the Army 4 years after that. And they gave me a leave of absence without pay to attend law school on a program that was known as the excess leave program.
Wow.
And what that meant is that during the academic year, I went to law school. I did not receive any pay, although I was on active duty. I did have, military status and identification and privileges to use the, any military installations, base or commissary or medical facilities. And then on the summertime or during the Christmas break, I went on active duty at the nearest military installation, which for me was Fort Bliss, Texas. That's the greatest oxymoron in the English language. And when I got there, that was a fabulous experience for me, because after the summer after my first year of law school, as a second lieutenant, I showed up at the legal office there and said, "I'm reporting for duty." And they said, "Well, great. We're 3 prosecutors short. You are now a prosecutor." And between
Wow.
And between my first and second year of law school, having not had evidence, I had criminal procedure and constitutional law and criminal law. So I tried 42 cases.
Wow.
between May and August, and 12 were jury trials. And I went back to law school with more trial experience than most of the faculty and a really bad attitude. You couldn't teach me anything because I thought I knew it all.
Oh, you knew it all, yeah. Yeah. Now I gotta interject and ask a quick question here. As I recall again from your bio, you attended your undergraduate school was at Berkeley?
No, Cal Davis.
Excuse me, Cal Davis, which much like Berkeley, I spent several years in San Francisco working for Summation back in the early days of them. But what was it like being an ROTC student at Davis in those days? Right.
That was actually, that's very interesting. And of course, the sad thing is, Tom, is that most of the audience will be listening to that saying, it's ancient history. What do we care? It was actually pretty interesting because Berkeley, as you might imagine, was the sort of the center of gravity of most of what was the subject of all the national and international conversation. Davis,
what we used to call the People's Republic of Berkeley.
And Davis was the agricultural, the Cal College, as they call it.
Right.
But we did, the times were as they were, and things were percolating, and we did have, the Students for a Democratic Society, the SDS, had the obligatory takeover of the ROTC building in the gym, and there was one time when. At the end of my first year, I was in the color guard, and we had a award ceremony, and the color guard was supposed to march at the end of the year out of the wing where the ROTC building was, and out onto this enormous intramural field, and there was supposed to be. All the troops were supposed to be assembled, and they would give out, medals, and we didn't have a band, so they had a record player of some martial music, and apparently there were that word about that had gotten out, and there were quite a few people there waiting to receive us, and in what probably in retrospect was not the smartest decision to make, our professor of military science, the head colonel, said, "Well, we're not going to call off this ceremony just because the people are going to protest. We're going to do our thing." So we wheeled out, and we, with the color guard marching at the fore, marched onto this intramural field, and they had dismissed most of the brigades. So what we had the ROTC Ranger guys, the snake eaters, and then we had the award recipients. So we probably had maybe 50 people, and we troop out the I guess it was the American flag. We had I had the American flag. We had the California flag, and then we had a person on either side of us who had a rifle that didn't work. One of those chromed up looking things.
Right.
And so we march across the street onto this. The 50 of us walk onto the street where this a reception committee of 4,000 people was waiting for us. And they just opened up like the Red Sea. And we walked in and they closed up. And fortunately, it was not violent. It was disruptive. And we were told to stand at attention, and under his breath, one of our captains, who was a great guy, who we really respect a lot, said, under no circumstances, do anything to provoke him. And I was thinking, 4,000 to 40, probably a pretty good idea that we'll stand right there.
Good strategy.
But I'm wearing my uniform. I'm already provoking them.
Yeah. So it ended the ceremony. Yeah. We managed to sort of eke our way through the ceremony. You couldn't hear too much. Somebody, I think, scratched the record that had whatever the martial music was. And then, having proved our point, we wheeled about and walked back. Now, the difference is that when in Berkeley, something like that the town council would have, issued some sort of proclamation of support for the protesters. Whereas in Davis, up where the farm community was, the local farmers volunteered to grab the pitchforks and ring the place with protection if we wanted to repeat the ceremony, so we could go out there, and they would be there with their John Deeres and their pitchforks, and they would be more than happy to make sure that we got to complete it. At that point, I think rationality prevailed, and we declared a draw, if not victory, and that was that. But beyond that, it wasn't too much. And I do remember that there were some probably things in retrospect that we did after that are probably less than wise. I do remember that the summer between my third and fourth year, I went to summer camp at Fort Lewis, Washington, which is a 6-week training program that you go to. And then after that, my best friend and I, who was in ROTC with me, we went back to Fort Benning, Georgia, for airborne training. And we were trained how to be paratroopers. And then we went back. And the last year, I was our Rachi unit's brigade commander, and he was the deputy commander. And we used to, once a week, have a PT. We'd get up and be out at 5 a.m. We would do our stuff, and then we would run through the campus, probably about 6 o'clock in the morning, singing Jody Calls, which was probably, not the wisest thing in the world, but it was sort of our way of saying that we were, that we were there.
We're there.
We were there. So,
yeah.
But that was it. It was pretty
good,
mild in retrospect, but interesting times.
Yeah. I lived in Sacramento for a number of years. My son was actually born there. So I know what you mean. That's a whole different world from the Bay.
Yep.
Total
Yolo
90
County.
Miles in a different world. Yeah.
Yolo County. Yeah, absolutely.
Yeah. So what, then law school, and then then active service?
Yep. I went to law school and, did my thing in the summertime and in the Christmas time. Got sent back on active duty. My first assignment was Aberdeen Proving Ground here in Maryland. And I started off as a defense attorney, and then when I started winning cases, they made me a prosecutor. So I did that for about a year, and I was supposed to be there 3 years, and then I got reassigned to the Pentagon, and I went to the Pentagon, and I was in the Administrative Law Division for 2.5 or so years, and then from there got out of the Army and became a state assistant state's attorney in Baltimore County, and then an assistant attorney general, and then after that, it was in private practice, but went into the reserves and stayed in the reserves to get my 20 years. And retired as a lieutenant colonel after, I think it took me probably in the neighborhood of 25 years to get my 20 qualifying years, because it's kind of hard in private practice to get the time to do it. But I managed to do it, and it was a wonderful experience. And the Army was a fabulous thing for me, and the people I met and served with were just spectacular. So it was a good experience for me.
My dad was a Navy veteran of World War II, and then afterwards joined the Army Reserves with an eye towards the same thing, to building up towards the 20 years. And then he spent, I think, 6 weeks in Fort Bliss and had the same reaction you did one summer. But then he got called up during the Cuban Missile Crisis. He goes, wait a minute, that wasn't my goal here. He's a school teacher.
This wasn't one.
He's teaching secondary school in a little town in suburban Boston. He's going, wait.
Yeah. And of course, I'm sure the Army was very concerned about his feelings and emotions. And
they took all of those into account. Yes.
Took that into account. And
it was report to the National Guard Armory at 6 a.m. tomorrow, 600 tomorrow.
Yes.
And, bring a toothbrush.
Yeah, if we wanted to hear from you, we would have given you advance.
Yeah.
Right. So at that time, were you also teaching, or you started teaching after you?
Yeah, I that's actually a great question. When I started teaching when I was in the Maryland Attorney General's office, and there was an organization with the acronym of MICPEL, MICPEL, the Maryland Institute for Continuing Professional Education of Lawyers. And it was a foundation that was sponsored by the two law schools in Maryland, the University of Maryland and the University of Baltimore, and the State Bar. And it was a CLE program. And I wrote a couple of books and got involved with doing teaching to legal education. And what happened was I guess it was probably 1994, 1995, Maryland, the state of Maryland, which you have to realize that the courts in Maryland have been around since the 1650s.
Right.
And part of the Maryland Constitution is that the common law of England as of 16 whatever is part of the common law of Maryland. And our Court of Appeals, which is our high court, our state Supreme Court is called the Court of Appeals, is the only state high court in which the judges, who are not called justices, they're called judges, wear scarlet red robes as a throwback to their tradition.
Yeah.
And so we had a wealth of common law evidence rules that had been adopted over time, and a few individual standalone evidentiary rules, but we didn't have the federal rules of evidence. And in 1995, the state adopted pretty much large scale the federal rules of evidence. And as part of the rollout of that, there was a big go around the state, to half a dozen venues and teach that. And I started doing that. And I ultimately wrote a book on taking and defending depositions, and did a lot of programs on that. And then that led to teaching as an adjunct professor at the University of Maryland Law School, where I taught pretrial civil procedure, and I taught, and then eventually evidence and scientific evidence, and then that in turn got me affiliated with the University of Baltimore, and today I'm an adjunct at both of them. So that is what got me teaching.
I got off the train in Baltimore a couple of weeks ago. As you know, Craig Ball and I were both at Georgetown, and we split paths on the train tracks. But I was shocked at the building at UMBC. That's like, when I used to go to school there, it was a nondescript little, 3-story building. Now it's like
it's edgy in terms of the architecture, but it fits in well, because, as you know, Tom, that's the what I would call the arts section. The Maryland Institute of Art is right there, and it's a very the dean there, Ron Weich, is just a fabulous dean. I actually had a sort of a minor role in the process by which he became the dean, because he was at that point at the Department of Justice, and he was I think he had been the chief counsel for Senator Ted Kennedy, and then was for the Speaker or the Senate majority leader at the time, and was looking to teach. And I was teaching a class then, and he and I have he is worked with in the Vera Institute, which is a think tank that deals with a lot of things, including a lot of criminal justice issues. And he had a lot of contact with Jim Bernard, our chief judge, who was also instrumental in the Vera Institute for many, many years. And so when I heard that just sort of incidentally from our chief judge and my colleague, that the University of Maryland was looking for a new dean, and at the same time had heard that he was looking, I was able to check with him and see if he would mind if I sent his distinguished resume, and they interviewed him, and next thing you know, he got the job. He's been the dean for almost 10 years, and he's just done a fabulous job. And so he's a terrific dean for a terrific school, and finally got a building that is very high tech. I mean, it's pretty much
it's a really nice building over there.
Yep.
Yeah. My dad and my uncle both went to Maryland, and my niece is getting ready to go to Baltimore. So yeah, it's got lots of connections over there.
if they're in the market to take an advanced evidence class, I'm their guy.
Yeah, well,
I still have scars on my body from freshman lacrosse play in Maryland. Yeah.
Yeah. Tom's experience in the state of Maryland was a little different.
Well, the problem with Maryland was at Hopkins, the football team was basically fall practice for the lacrosse team. In Maryland, it was the opposite. They had all these huge football players who turned out and loved nothing better than beating the living daylights out of a little private school from up the road. And they did.
Yes.
And they did.
And they did. But that's all right. The Blue Jays, they were indomitable, if not indefeatable.
Back then, not so much anymore, but not, it's a different time.
Different time.
We played on real grass and under sunlight.
That's right. When college sports were really college sports.
Yeah.
Whatever they are now. Yeah.
Which is something different.
Yes. Yeah, we won't go there. As a Notre Dame fan, I don't want to even talk about going there.
Right. So I wanted to pivot the conversation a little bit, since this is the EDiscovery channel, and talk a little bit in terms of get some of your thoughts on where we've come over the last 10 years, specifically, since you've been a judge and a federal judge, and really kind of what you've seen, because a lot of people who watch and listen to this, are relatively new to the industry. They're people who don't necessarily even have the legal background. They're coming to it strictly from a technology background. So one of the comments that we typically get is that it's fascinating, hearing from people who have been involved in transition and the changes over the course of the last 10, 20 years. From your side, sitting in the judiciary, what have you seen as a change from how both plaintiffs, defendants, how they're approaching electronic discovery, what they're, what kind of things are showing up in your docket and the challenges associated with them? There's a lot there.
Yeah, that's a great question. It is. I think to really sort of get your arms around that, you have to go back just a little bit farther, maybe 20 years, because the lawyers in my generation, when we were involved in a big case, it was all hard copy documents, and you might walk into a room, a pretty good sized room, that had these banker's boxes about 18 inches by 18 inches by 24 inches, and And, you had to go through all those, and you had to, manually stamp them with a H stamp that would keep the numbers and analyze them and come up with indexes. It's hard for many of the young people to imagine a time like that. I remember the first computer. I had a big case, and the insurance company wanted to have have the information put it in a database, and they bought a laptop that they had delivered to my firm, and a paralegal manually entered information, and it was DOS, and so there was no Windows. I remember in 1995 when Windows 95 came in, and it changed everything, because for the first time, instead of having to do, all those symbols with the keys, you could actually visually see things. Right. And you could click it open. It was just, it is just almost hard for people who have not grown up in that environment to imagine what it was like to transition in that short time. So if you start with like 95, from 95 to 2000, because, I remember buying my first PC, which was a Dell, and I think I paid $3,000 for it. Right now, if you told someone you pay, it probably had 32 gig of memory. And people had servers. Right. It was just a completely different universe then. But what happened is that the Windows, and then Apple ran behind for many years, and then of course when Jobs came back in, they came out with the MacBook, and of course all the other competition came in, and you had many different platforms, and it democratized the availability of computer resources to everyone, to law firms, to people who are actually doing things. And I remember when I was in the Attorney General's office, and these computers were first coming in, litigators were of the view that that may be great for people who do the states and trusts, where they have the basic forms and they just go in there and do a couple of things and change it, but that'll never take on for litigation. And then what happened is that all of this information became available, and devices, you went from desktops to laptops. Remember, the iPhones, those are only 12, 13 years old. Right. So before that, we had those flip phones that you would send. I distinctly remember my daughter, who is now an attorney, contacting me when she was in middle school or something, had a phone, the old flip phones, and saying that she was going to send me a text message. And I said, well, what's a text message? And she said, well, you just use your phone, and you use the keys of your phone to send someone a message. And I said, well, how's that different from email? And she says, well, it's a different sort of, it's similar, but it's a different kind of thing. I said, well, that'll never.
You're lucky that she let you actually ask and explain, as opposed to just saying, old man, go away. You don't know.
Well, I was thinking it, but I remember thinking, well, that'll never catch on.
Who's going to do that, right?
Who's going to do that?
If you have to do the T9, then
it'll never catch on. And then of course, once the phones came in and they started adding things, everything was gone. So what we ended up with was in the civil area, and I was, timing is very important. And I was in that era with a lot of people who I considered to be greats. My former colleague and dear friend John Fasciola. You had Andy Peck, you had Jay Francis, Dave Waxy. You had, Liz Laporte. You had a bunch of these people who were, we were all at the same time. And at that time, the Sedona Conference, Richard, was alive, bless his soul. And it was kind of like, it was a clearinghouse for people from all over, from the academics, from the defense, from the plaintiffs, the technology people. And we were kind of making it up as we were going on. And so as a result of that, we had to deal with something. And you'll recall that the 2006 changes to the Rules of Civil Procedure came in. They tried to do some tweaks, but wasn't really purpose met for what we needed. In 2009, I was appointed by the Chief Justice to be on the Civil Rules Advisory Committee, and spent 6 years on that committee and chaired the discovery subcommittee. And we undertook to come up as a committee with what became the 2015 changes, where we really tried to focus on some of the issues that had presented themselves. What has happened in that 20 years is that it's hard for people to remember that in 2003, Mark Zuckerberg was a sophomore in Harvard, and he came up with Facebook as a social media thing to meet people, get dates, and do those things. Facebook is a different animal now. In that 20-year period of time, the social media platforms have exploded. Everything is done now in digital format. And in the cases that we see as well, all the evidence is electronic. That's where we see the evidence. I don't think I've had a trial in the last 10 years where some of the most important evidence wasn't electronic in some fashion. And electronic is sort of more than just simply documents, electronic documents. That became the focus. We changed the rules of civil procedure. We came up with a lot of procedures. We talked about search terms and everything. And then with Maura Grossman and all the other people like that, we got technology assisted review. And when Andy Peck had a couple of opinions that said this is okay to use, then people were willing to use it and not run the risk of using something and being told that they had to repeat it again because the judge didn't know what it was. And that's pretty much developed pretty well. There's a whole infrastructure of technology people and legal people who are in this. I mean, I don't mean this in a pejorative way, but in the electronic discovery bubble that they're constantly involved with that. When you get outside that bubble, when you talk to most judges, they'll say, yeah, well, I don't get that stuff many times. It seems to take care of itself. And the cases where you have the big ESI cases, the lawyers are usually pretty good about that. And what's changed now is everything's electronic. We now have new generations of lawyers who are digital natives, and they're not afraid of the technology. They understand it. And we have new generations of judges who understand it. In my generation, we're the dinosaurs. We're the ones who are becoming extinct or soon to be extinct. And as a result of that, we're now transitioned on to new challenges in the technology area, an area of my immediate concern, which is artificial intelligence software platforms, because they're ubiquitous, they're everywhere, they're being used now. And my focus now is on making sure that we have intelligent evidentiary analytical tools available when we get to the point which we're now beginning to see, but it hasn't manifested itself in any published legal opinions, issues associated with admissibility of evidence generated by artificial intelligence, because then you are really concerned about making sure that, since there are no standard protocols for AI programs, the testing of them, how accurate they have to be, how transparent they have to be. We don't have any statutes. We don't have any regulations. We don't have any best practices. They will come. That they're being looked at now. I know that the National Institutes of Standards and Technology, NIST, which is a science and technology outfit with the Department of Commerce, has gone to the American Association for the Advancement of Science, the AAAS, and asked them to develop some standards for AI use in the courts. I'm on that committee. And Maura Grossman and her husband of 2.5 weeks, Gordon Cormack, and I just had an article published at Northwestern Law School's Journal of Technology and Intellectual Property. It hit the
blurb on that this morning. I just got an email blast on that. Yeah.
Yes, came out Friday, and analyzing what is artificial intelligence, what should you be aware of, and then talking about the evidentiary standards. So we've gone from a point where no one knew what any of this stuff was. I mean, I remember, and it sounds funny now, people say, asking what's metadata, what are load files? And as a result of that, what's happened is pretty much everything has transitioned. The new reality is that technology changes constantly. At some point people stopped, having servers in the cloud came in, and now the cost of storage is almost laughably small. So everything exists and it's all there. The one thing that has not happened in a way that I think is particularly helpful is that there's so many different competing versions of the new best method of search, vendors coming out and different approaches, that it's very, very hard, I think, for someone who's not really daily in this area to sort of know. I mean, I don't know how you would come to it if you went online and said, what kind of search tool should I use for litigation? You would have so many different things. There's no common language to be able to compare them. And I think that's a challenge. And we've seen how a lot of these companies have been sort of absorbed by other companies and been around and then gone. So it's kind of hard to, we have legal standards that are to be applied. But the technological standards, there's not necessarily the consensus that you might have thought that this much time in the process would have developed. And in addition,
that's probably a lot because so much is vendor driven.
Yeah.
Because you didn't have the attorneys who grew up native technologists. So it defaulted to the vendors and they took over the industry from that perspective of, we're going to offer our perspective on it and not necessarily the perspective of the law. And I think, that probably drove away some of the standardization that would normally come in this type of area.
Yeah, and the notion is, this is not criticism. I mean, competition, produces better results, but you have to be able to evaluate the product of various formats to be able to determine which is the superior one, and then try to look at what the pricing is. And we have people, Craig Ball, who is, we started off back in the day bumping into each other at programs, and in the course of time, he's become a very close family friend, and he's been a savant in this area forever, still writing very, very, very useful information on that, and trying to convince attorneys that they can learn and need to learn the technology of it. And so that part is sort of developing in its own area. Within the courts, you still see if you and my LLM thesis was focused on this, but I took a quick look at where 75% of all the discovery opinions that are being authored in the federal courts are being authored by the magistrate judges, because they're the ones who are handling all this. Mm-hmm. The district judges, some of them, refer all their discovery disputes to the magistrate judges. And if you see a district judge opinion on one of these issues, it tends to be a challenge to a magistrate judge's opinion, and they're looking at that. And generally speaking, they concur with it. The magistrate judges are, by and large, that they usually come to the job at a younger chronological age, and are very qualified and very talented and not afraid of it and equal to the task. So that part sort of manages itself fairly well. In the big cases where you have the people who do this all the time, they do a pretty good job of working through the kinds of things that create problems. Now they may have a problem with cost and things of that nature, or access or some of those things. But the old days of fighting over how you search terms, we still had that little kerfuffle about if I train my device to be able to search, I don't have to give you the seed set that I use to train it, because it's my work product. And I think probably it is their work product, but you don't want to be too clever by half, because eventually, if you're not willing to show enough transparency to convince the other side that what you're doing is appropriate and fair, then what's going to happen is you're going to get you're going to get a challenge, and it's going to go to a judge, and the judge is going to say, well, why should I take your word for it? Well, judge, back in the paper day, if I look for it and I came back and I said, I look for everything and I got it, no one would dare question me. And now they want to see the seats there. I said, well, perhaps you should have stayed in the paper age, but we're no longer in the paper age. And if you're trying to convince the person who's going to decide whether you can rely upon what you did, then you've got to be at least transparent enough to be able to, describe that in a way that justifies that it was an appropriate search. So there's still some areas of, of potential friction. But, when you talk to most district judges, most of them will say, well, we don't really see all those kinds of disputes. So it's kind of a disjunct on that. Where you do see it is the evidence itself. I mean, what a smartphone is being used to do and what it connects with and how you can find out information about that. I mean, I've had the privilege of doing a lot of CLE programs with Craig Ball, and he's been enormously generous with his time, as he always is, and come out and of his own time, free of charge. He's given probably half a dozen to a dozen training programs to Maryland judges, and they love it when he comes out. And I've been on part of those programs. And when he starts going through what you can find out about a person when you have access to their cell phone, you look in the room and you get this, the eyes get really big.
Yeah.
It's like, what? And now people, are smart enough to ask for that. And we're starting to see that now in search and seizure warrants and in criminal cases. They know to get that stuff and going back and trying to get it. So I think that people are much more attuned to the notion that technology is kind of running everything. The development of social media and its pervasiveness on all the different kinds of platforms is such now that social media evidence is being used in criminal cases. You would think that if I was going to be part of a drug conspiracy or a gang, that I would not want to go on the social media site and brag about what I had done. You might be mistaken. If that's how
you'd be very mistaken.
Yeah. And there they are. So I think everyone now has become accustomed to the notion that technology is ubiquitous, it's unavoidable, it's baked into it. Technology changes constantly. And the product of technology is where the evidence is, and sometimes usually the most important. I mean, I just not long ago had a money laundering case involving money laundering conspiracy that was part in the United States and part outside the United States, and the whole case was text messages and electronic transfers and communications where the criminals who were committing the fraud that was getting people to send money to under false pretenses that was then put into bogus accounts, ostensibly legitimate business accounts to launder it. The whole case is electronic. And, you get a case now where, you're trying to prove somebody was doing something at a certain time, cell phone location information becomes absolutely critical, particularly if you're trying to show a connection with interstate commerce and showing that a phone moved. And so those things now, in terms of the actual finesse with using electronic evidence, I see the prosecutors having much more experience in that in terms of in court, stand up on your feet and do it skill than civil lawyers, because the cases never get to trial. So it's kind of flipped. I remember back in the day when in the criminal cases, they were saying, well, how could we possibly, do anything other than look at everything? I mean, how can you search all this stuff? You have to look at it all. And say, well, have you been paying attention to what's going on in the civil area? Now they're very sophisticated. They come in there and do that. So that's the interesting thing is in litigation, where we see the litigation of this stuff is increasingly in the criminal areas, not the civil areas. But I think that in many cases, civil. I mean, if you're talking about an intent case, text messages and tweets and all that stuff, that shows what people are thinking when maybe their public face is saying something differently. Fraud cases, contract cases. So where we are now is, I think that the mindset is to say, well, we all accept that technology is driving all of this. It's going to be there. It changes. You get sort of, groups within things that say, well, this is the new best way to do this, to try to control costs. And someone else says, no, you're not taking into consideration these factors. Those debates will always be there. I don't foresee any dramatic changes to the rules of civil procedure. After 2015, it was a 5-year effort to get those rules across the finish line. And there are critics of what we did, and people who think that it improved things, people who probably might disagree with that. But overall, it was done with the greatest level of understanding of what needed to be the rules available in civil cases to be able to get the process one where people could at least have some guideposts as to how they were going, and the courts have pretty well moved forward on that. But I think that's where the environment has changed, and the question is now going to be, what's the next technology? Big bang, because it'll be here. We all know that, but I think it'll be powered by, if not largely related to, artificial intelligence.
How about something a little bit simpler in terms of technology, but something that I think is very much impacted by technology? And I know Tom's thoughts on this because I just recently heard them in regards to dealing with privilege logs and the vast tsunami of data that comes now in your standard civil case. And all of a sudden, that's multiplied out when it comes to actually dealing with privileged documents and the logs. And any thoughts on where or changes that may, because we really haven't seen changes over the last 10, 15 years in regards to how privilege is dealt with. But yeah, I think it's time, and I know what Tom's thoughts are on it, but was wondering what yours are.
Yeah, this is a tough area, and it's a tough area because in a civil case, you go back to the notion that the scope of discovery is the matter is relevant to the claims and defenses that have been pleaded that are not privileged or protected. And given the data, the amount of data that's there, given the way in which discovery is still being done, I mean, it may be powered by technologies at the review that may go through a huge data set, but you get large amounts of data that are then deemed to be relevant by the training that was given to the electronic method to search for it. And then they find themselves into, your traditional privilege log. And I remember back in the day that I heard about a case where Judge Schindlin, had a 30,000 page privilege log. Mm-hmm. There's just no way in the world that you can deal with a 30,000 page privilege log. It's just too much information. The other thing too is that, people think of attorney-client privilege and work product protection, and, evidence rule 502, which is near and dear to my heart, since my Hudson versus Baltimore City Police Department was the case that's cited by the Rules Committee, and the changes that went into effect for the evidence rules that helped come up with 502. They helped, but we didn't get this notion of we just turn it all over and then you pick out the stuff you want to use in evidence, and then we'll tell you whether it's privileged or not, for the simple reason that once they know about it, it doesn't, they can't use that which is privileged, but they know about it. And you have to be a pretty dense lawyer not to be able to figure out a way to ask another discovery request or request for admissions for the same information. There's no ability to get a lobotomy for the lawyer that looked at it, who can no longer, use that information, but knows it's out there. They're going to find a way, nature abhors a vacuum, and they're going to find a way to get it. So it's become, it is a bone of contention. It's always a problem. I think, there were some workarounds that people kind of came up with. I think that Steve Sussman famously had a late great lawyer in all of this, and just a giant in the litigation field. He had a thing where he would say, all right, you can pick any 10 documents on my privilege list, and I'll pick 10 on yours, and pick them at random. And if the judge doesn't agree that 8 out of 10 are, then I get them all. And he evidently got people to agree to that. But the problem with those is that there's no the traditional way of a privilege log that when you assert privilege, 26b5, you got to assert it with particularity. And of course, what happens is that you can't expect for each entry in a 100-page privilege log to have, a 15-page affidavit to support it. So, our discovery guidelines for our court, we have sort of what we think is a logical approach. You assert it, you put in enough information so that the other side can say, am I interested in this? And then if they come back to you and say, we're challenging the designation, now you got to back it up with more information. Mm-hmm. And you reduce the field that way. And then at that point, I think that, well, let me phrase this in the proper way. And I guess I should say it at this point, where I should have said at the beginning, is that everything I say are my own personal views, not that of any other institution, the schools where I teach or the court that I serve or anything else. But if there is a federal judge that likes getting involved in privilege log disputes, I have yet to meet her or him. Oftentimes the magistrate judges get involved in that. Part of the problem is that, we're still in the area where discovery is getting, terabytes are small now. I mean, that's, terabytes, anybody can deal with a terabyte. We're dealing with an ectobyte or a nanobyte or whatever the hell, whatever the next great thing is. But there's no trial in the world where you're going to put in even 100th of that kind of information. You expect the jury to look at it. And so what I think has been kind of the problem that has spurred this is that you need to get away from the notion of, I need to look at everything in order to be available, and trying to figure out, what is the stuff which is really important. I need to prove my case. Steve Gensler, who a professor at University of Oklahoma Law School, really forward-thinking guy. He has a great book that he started off. Well, it was his only, and now so much is so large now, and there's so much effort to do it that he's got another professor who's also co-involved with it. But his treatise is very good. But he came out with the bullseye theory of discovery. He published a paper on that. I think Sedona published it. You imagine a target, you shoot for the bullseye, you don't shoot for the outer rings. People ask for everything, they ask for too much. They get down to stuff which they know what they want, but they don't know what is there and whether they've gotten it all. I think that probably if we had a technical solution that looked at better methods of search, trying to look at the information. The challenge is that if it truly is privileged, you have absolutely no right to it. There's an absolute bar against you getting it in discovery or using it absent privilege. The problem is that each privilege has multiple elements that have to be established for each document. And what you get is that you get a document, and you can't just do document by document, because you have portions of a document that might, but other parts may not. So, and what you end up with is that the legal work required to be able to resolve these things is challenging. It's technical. It's hard. You have to remember that even after Iqbal and Twombly, with the additional information that most plaintiffs have to plead in order to have a plausible case, there's still just a barest outline of what the case is about that's filed. The judge doesn't see the discovery requests or the responses unless there's a motion. So we don't have a lot of factual information about the case. The parties develop that, and when something pops up where they file a motion, then the judge gets dragged in. But the lawyers talk about in-camera review, and that's that is just not smart thinking, to think that the judge is going to say, yeah, back that truck up there and put it all in there.
Right.
Yeah. I'll spend the rest of my career looking through these things. I don't know what's relevant. I don't know what the case is. So the parties have, the other thing too, is that privilege logs are prepared by the least experienced people on the team, most risk adverse, people who don't, so what we never got, we thought that, 502, D orders and would make it a little bit easier for people to sort of, get the information out there, find out what's important, and then go back and argue about privilege. That just didn't work out. Lawyers are still very, very, very worried about privilege waiver. Clients, they don't want their privileged information disclosed. I know, I think that John Fasciola has given a lot of recent thought about improving privilege logs, and there may even be some recent stuff. I think he and I think he was working on that with some other folks, and I think that we're even going to have a program on it recently. But I think that they either did it virtually, or they were going to have it in in person. But concerns about health prevented that. So I recognize it's a problem. I don't think there's any brilliant solution that has been asserted. The difficulty is volumes of information over conservatism, small c conservatism, in terms of people asserting it when they really does not meet all those elements. I've done things like issue orders that say that the senior partner of a case, the person 15 lawyers up, has 48 hours to personally review every entry in the privilege log and to provide me with an affidavit that says that each and every privilege log assertion, that there is a factual basis and legal, that they have personally reviewed it. That tends to, I never hear from them after that again. What happens is they sit down and figure out a way to work it out. That kind of blunt instrument approach is probably sometimes successful, but it's not ideal. There's not much you can do. The rules of procedure under the Rules Enabling Act, you cannot create or abrogate an evidentiary privilege. It's got to be done not by ordinary rulemaking. It has to be done by an enactment by Congress. And Congress, when we get to privileges, people are very, very reluctant to narrow the protection that privileges give them. And the privileges, you go to Evidence Rule 501 that says the law of privilege is the common law of the United States. Go out there and take a look at it. And now that's why we got into 502D, because you couldn't have a rule of civil procedure that says, nah, if a court enters an order and it's disclosed, it's binding on everybody. You couldn't do that because of the Rules Enabling Act. It had to be affirmatively enacted by Congress, which is what happened to 502D. The rules committees came up with a proposal, and then it was enacted by Congress. So you can see what it takes to try to get a change to deal with this area of common law. So it's going to be there. I think if I were going to try to imagine how things would be, is to sort of get beyond the individual leaves on the individual trees and look more at the forest. What are we really trying to get here? And is this a ditch I want to, I'm willing to die in, and trying to narrow it down. But I can tell you that going to the court and expecting a warm audience when you have a whole lot of privilege issues is not likely to be,
not going to happen.
Not going to happen very often.
Yeah. So Tom, we've got 3 minutes left.
All right.
You want to wrap us up?
Real quick, I actually have a penultimate question, Judge, which we spring on everybody. I'm going to tailor it slightly for you. I ask everybody, Beatles or Stones, but for you, I'm going to say Beatles, Stones, or Zydeco.
Well, I mean, the Stones are, of course, the ones that I have always been a Stones fan. No knock against the Beatles; they were great. But in terms of Zydeco, you just can't. You want to talk about roots music? That's the great thing right there. It's a little, I guess it's sort of come back. You see Zydeco creeping into some other things and more mainstream, but it is pretty wonderful. But I've always been a Stones fan and probably always will be. The trouble is now that I used to think that the greatest advice you could give to anybody in discovery was, you can't always get what you want, but if you try sometimes, you might just find you get what you need. And I say that now, and the students look at me like,
what?
What? Stones?
Yeah.
And I see the picture of Mick Jagger. I mean, God bless him. He's physically active at 80. It's unbelievable. But I look at him, I go, my God, Mick, you look like the picture up in the attic that,
Dorian Gray, right?
Yeah. I said, it's at some point. But
Yeah, but God bless him. He keeps on churning.
Oh,
So,
yeah.
last question that we ask everybody is, if you could spend a day with anybody from our profession, living or dead, who would that be and what would you do?
Well, I already know the answer to that because, as I mentioned before, Craig Ball is someone who I think is a legend of our profession.
He didn't die, did he?
Well, he thinks
You
people
said
think
living
he
or
has.
dead. You said living or dead. Come on, Tom.
Living or dead.
Yes.
Oh, all right.
And,
All right.
and,
Fair enough.
And I have had the pleasure of spending many days with Craig. He is very thoughtful. He brings some unique qualifications because, of course, he was a lawyer and knows how this stuff is done, and he also has some technical proficiency to it. He's not afraid to speak his mind, and he's got he's pretty thoughtful in what he does. But what I think would be great if I could sort of expand on that is if you could get back all the old geezers, get Fasciola and Peck and all those people together in a room and ask them to sort of talk about where they are now and what they think has happened and where we are. I think that would be interesting because I think that what it would show is particularly, Andy's now in practice. And I think that Jay is doing work as a special master. John Fasciola is teaching, and he's a special master as well, and doing that stuff, and getting them to sort of talk about what they think, because they were there sort of at the beginning. And then I would want to have the new breed there and have that sort of just a kind of a come together and what have we learned and what are the next horizons? That would be kind of fun. We did that.
Go ahead. I'm sorry to interrupt.
No. I'm supposed to shut up, and I didn't. But we did that at Duke, for the conference that launched the changes for the 2015 rules.
Right.
We had all those people come in for 2 or 3 days, and we had people from technology, we had people from state judges, federal judges. We had lawyers of all different kinds, and Fasciola was there. I think we said it was just like Woodstock without.
Oh, I was going to bring that up, but I didn't want to put you on the spot. Go ahead.
It was exactly like Woodstock.
That's right.
No,
like
tell the story.
It was just like Woodstock without sex, drugs, or rock and roll. And you had all these, but it was great because we took a look at it from this, big thing, and we carved that and sliced it up, and it went out, and some things came forward, and then we came up with these rules, and you come up with new rules. The lesson is that you can, you get new rules, but new rules don't change everything. You have to change behavior, not just the rules. People have to follow them, and they have to be interpreted, and they have to go forward. So, I think that the good news is that these issues are all important. They're still involved in where people go. They'll still be a source of discussion. The new generation will take over, and those the rest of us will, what is it MacArthur said? Old soldiers never die; they just fade away.
Fade away.
We said as old ESI, judges and technologists never die; they just get deleted.
But is it truly deleted?
But we're really not deleted. We're out there with
space.
That's right. You'll be out there where you can get brought back if somebody knows how to do it. That's right.
That's right. And you just better hope that somebody thinks it's worth the effort to bring that particular person back. So. Well, this is a lot of fun, guys.
Well, thank you.
Appreciate it.
Judge, we really thank you for your time. I know you've got to go. You've got a full docket, I'm sure. But we appreciate your being here. Please have a great holiday season and a wonderful new year. Hope to see you in person sometime soon.
Yeah, I told Craig we got to come down to your wonderful city down there. We're due for coming back, and what a special place it is. So take care, everybody. Been a pleasure. Happy holidays. Stay safe and well. It's been a pleasure.
Thanks, Judge.
Bye.
Bye-bye.